you ready to get started?
Ready.
You're ready.
Okie doke. For those of you who I have not met yet or who may not have heard of me, my name is Bruce Hammer. I'm the new managing broker, aka broker of record here. I got my salesperson's license in 1988, got my broker's license in 2004. I have graduated from law school, so I know probably a little more about contracts than most. Let's see. Formerly had my own brokerage. We dissolved that at the end of the year, and I probably closed a couple thousand transactions in my career. So I've had a lot of experience dealing with California's contracts, whether listing agreements or residential purchase agreements, going all the way back to when I started in the Bay Area and the contract was like a couple pages. So I've seen it kind of evolve into this mess that we have today. What I'm going to do is, I'm not going to tell, this class is not, it's not for the purpose of teaching you how to get a listing. That's marketing, and you'll learn that in other areas. It is to teach you kind of some of the important stuff that goes along with completing a listing agreement when you meet with a client. And there's a lot of areas where you can get into trouble, regardless of the fact that they've built these forms so that you can complete them pretty seamlessly if you just read the verbiage. But I want to give you a few tips and tricks and some stuff that maybe you don't know. I'll be honest with you. I've been doing this a long time, and I still learn stuff every time I attend a class on these. And a prime example is just this last week, I attended a refresher course on the listing agreement with Dave Tanner of SAR, and I actually learned a couple things in the course of that class that I didn't know. So if you bear with me, I'll hopefully impart some helpful information to you guys. And if you have any questions, put them up on the board, and I will hopefully get to them at some point in this thing for you. No question is a stupid question, so feel free to ask away. And I will, there's some areas of the formworks here that will be kind of glossed over because they will actually be covered later in separate courses. One example might be fair housing. That's an important enough subject that it really requires a separate class. But there are some fair housing issues involved in a listing agreement, and so I'm going to touch on them here, however briefly. So let's get started. What I've done here is I've prepared a listing package similar to what you would print out of zip forms. Now, everybody has a different way of doing listing paperwork with their client. My preference, and I'm old school, is I would show up at a listing appointment. I would have all this paperwork ready to go, except I would not put in the start date, the end date, the price, and a couple other things that were up to the discretion of the seller when I met with them. And assuming at the end of my presentation I was able to convert the listing, I would pull out my listing agreement and go through it. The difference that I would do is I'm an old schooler, and actually I should ask really quickly. Can everybody hear me okay?
I hear you.
Okay, cool. I'm an old schooler, and so what I would do is I would actually print out 2 separate copies of this entire package. And if I got the listing, I would go through all of the first one with the client, have them sign an initial after each section, and then I would just take that, I would replicate it on the second one, have them sign an initial. That way I could leave him with a copy of it while I was there, which is what we're supposed to do. Some of the more modern agents, they'll complete it on a tablet or on their pad or computer, and at the conclusion of the seller signing, they just email a full copy to the client. Regardless of which way you do it, the important thing to understand is the seller has to be provided with a copy of this package when you complete the signing and before you leave the house. That's the law, and you got to follow that. Secondly, let's just go ahead and dive into this. The first document that zip form includes as part of the listing package is the disclosure regarding real estate agency relationships. And I'm going to tell you guys, I don't know your level of experience. You guys may be seasoned professionals. Maybe it's the first time you've ever seen these forms. I don't know. So I'm going to kind of drop this down to the lowest common denominator, and I might explain stuff that's kind of repetitious to you guys, but just bear with me and we'll get through it. Basically, this form tells the client who you are representing. And this has been required in California going back since before I started. And it's important because DRE will always look for this when they audit a file. And if you ever have to go to court, this is going to be something they look at too. So I've highlighted some areas of interest and I've underlined some areas. Basically, when you go into a listing agreement, what I do is I'll sit there and explain to the client, this is an agency disclosure. This is my way of disclosing to you who I'm representing. In California, you have 3 ways that you can have an agency with a client. And an agent, for those of you who don't know it, is somebody that's given either actual or imputed authority by a client to act in their interest. And their interest is kind of the key term here. If you're a seller's agent, you owe a fiduciary duty to the seller to act in their best interest in good faith and to avoid any underhanded actions or self-dealing. If you're a buyer's agent, you owe the buyer that same duty. Now the key thing here, and this is, for sellers agents, buyers agents, this is kind of the important thing I want you to understand. If you look on this form and you see where I put a couple asterisks, each of these sellers agents and buyers agents, they really owe the exact same duties to their client. But where this gets interesting is they also owe the same duty to the opposing party. So if you're a seller, you're a listing agent or a seller's agent, as it would be called, you owe the same duties of honest and fair dealing and good faith that you owe to your client, the seller, to the buyer side, and vice versa. So if you just keep this in mind when you're working with your clients, that will be immensely helpful in keeping you guys out of court, avoiding ethics complaints and all that other good stuff. Just remember, everything you do in your practice should be honest, forthright, and working in good faith. Now, that doesn't mean that you have to give away information about something that you may have heard of that happened in a neighborhood 5 years ago to the other side. What it does mean is if you're representing a seller and you find, you're walking around the house and you're doing what we call a diligent inspection, which is what will go into your agent visual inspection report. We'll talk about that a little bit later. But if you're walking around a house and you see something that indicates there's a major foundational issue with this home, and you bring it to the attention of your seller, and you say, look, I think you ought to get an inspection here before we put it on the market. And your seller says, you know what, I've seen that crack on the foundation. I don't think it's a big issue. I'm not going to do anything. Well, when you do your agent visual inspection report, you need to make note of that so that it will be disclosed to the buyer, because it's something you can see. Likewise, if you find out, if your seller, when you're taking the listing, tells you that 5 years ago, before they bought the house, there was a husband who murdered his wife that lived there. Well, it's more than 3 years, and you'll find out later that, if there's been a death in a home less than 3 years, it has to be disclosed. If it's greater than 3 years, it does not necessarily need to be disclosed unless somebody asks you a specific question. So in a case like that, the buyer side comes back to you and says, hey, I heard from the neighbor there was a murder in that house. you can't say, no, I don't know anything about it, or no, it didn't happen. You've been asked a direct question, you have to answer. And that kind of goes to these additional duties that that the form refers to of honest and fair dealing and good faith. That's kind of the catchphrase. Now, agent representing both seller and buyer. You will run into that situation. You're going to list a house and maybe you hold an open house or something and some buyer comes in there, he's looking, he says, yes, I love this house, I want it. And you immediately get that person pre-approved, or it's a cash buyer, you verify funds, you write up an offer, so on and so forth. The moment that happens, you become a dual agent, which means you have to disclose to both the seller and the buyer that you're a dual agent. And failure to do that can have massive ramifications, both regulatory and contractually. So what is truly dual agency? Well, let's just say that I believe there's roughly 275 agents that work out of Keller Williams Sac Metro. You start working here, you list a house, and whether you find a buyer and bring an offer in for your seller, or another agent, another of those 275 agents here that you've never met, you've never heard of, but his license is hung under Keller Williams, say Sac Metro. This transaction is dual agency because dual agency is determined by the broker, not by the individual agents. So if you have two agents associated at the same brokerage, if there's 1,000 agents in that brokerage, it's still dual agency. And you have to make the appropriate disclosure to both sides of the deal. So that's what this
Does that also mean if it's another Keller Williams, not
when you are a dual agent, it gets a little sticky sometimes, because if you hold the listing and then say you're working with the buyer and the buyer says to you, well, what will the seller take? Really, you're not allowed to give them an answer to that question. And I know you're going to be tempted to do it, but just don't go there. What you can say to the buyer is, these give you examples of what you can say. You can say, well, look, we put it on the market 3 days ago. We've had 25 showings, and I know there have been 4 offers received already. What you have to do is, given that information, and I can pull comps for you and show you what the comps are, but you have to realize that, in this market, it might go for more than, the fair market value. You have to make a decision on what you are willing to pay in order to get the house. And if you stray beyond that, then you're actually violating your duty to your listing client. Ideally, if you're listing a property, you want to get the highest and best price from a ready, willing, and able buyer. And if you're giving hints to a certain one in order for you to double end the transaction, not only is that unethical, it's a violation of your agency. So just be wary and be careful of doing that. Let's see, buyer and seller responsibilities. The way I explain this to the client is, as a seller, you have a duty to disclose everything that you know about the property, to help us facilitate the sale. The buyer has a duty to not be ignorant, go into this transaction, do their inspections if necessary or if warranted. And then I've underlined something here that's kind of important, and this is something I preach throughout the real estate transaction. You are a licensed salesperson or a licensed broker. That's the license that you have. You can facilitate the marketing, purchasing, or selling of a piece of real estate, whether it's residential, commercial, or whatever. You are not, unless you're an attorney and you sign a retainer agreement or a legal representation agreement, you're not licensed to practice law. You don't give legal advice. You don't give tax advice. If somebody has a question regarding the legality or lawfulness of doing something, or tax ramifications of doing something. It's nice for you to have a bunch of CPAs or a bunch of real estate lawyers or whatever in your back pocket. You can give them a list to choose from, but you should never be giving legal advice or tax advice. The only limited type tax advice you can talk about is you can talk about the fact that once they purchase the property will be reassessed at that purchase price, and their new property tax valuation will be based on that purchase price. But in terms of tax liabilities for sellers or anything like that, you just don't want to go there. Because once you do take that step and go there, then if you give incorrect information, you're liable for that information that you gave. So, that'll raise its head all the time with you. Let's see here. So if you're representing the seller, you'll have the seller sign here. If you're representing the buyer, you'll have the buyer sign here. The agent is always going to be Keller Williams Realty, whether it's Sacramento Metro or Capital Valley, and it's the DRE license number of the broker, the brokerage. Salesperson or broker associate will be your name and your license number. So, move on here. The second page of the agency disclosure, a lot of it is just definitions. It describes what an agent is, what a buyer is, what a listing agreement means, list price, what the seller means, and it talks about the requirement that that the seller's agent is going to provide an agency disclosure before entering into the listing agreement, and the buyer's agent will provide a disclosure form to the buyer as soon as practicable prior to execution of the buyer's offer. So generally, the first document in any of those packages, you want to be the agency disclosure. And if you do it the same every time, then no one ever can dispute that you don't do it that way. Talks about dual agencies here. Again, just one more reminder. The next document that's now in the form is the Fair Housing and Discrimination Advisory. This is one area that gets a lot of agents caught up and in trouble. And we're seeing it more and more. And just so you know, the Department of Fair Housing, HUD, they do secret shoppers, and they will make telephone calls, they'll ask questions, they will try to basically set you up for a fair housing violation. So, and they're very easy to avoid if you know just some very basic information. So I'm not going to cover everything here, but I do want to say that there are fair housing laws devised under federal law as well as ones through the state of California. Most of them overlap each other. But the thing that's really interesting about the way these laws have been devised is under most types of federal and state laws, an attorney can't really get paid for launching a legal action. With fair housing laws, they've designed the acts so that an attorney, if they find a client that can show a fair housing violation, they earn attorney's fees. Same with like the Americans with Disabilities Act. That's why you have attorneys, and you may have heard of this one particular one around here. He used to go into restaurants and gas stations, and he was in a wheelchair, and he would try to go into the bathroom, and if they weren't ADA compliant, then he would threaten the entity with a lawsuit for a violation of ADA. And the beauty of that for him was if he was successful in the lawsuit, if they didn't settle ahead of time, if he was successful, the courts by statute had to grant him reasonable attorney's fees. So he basically made a market for himself by doing this. As far as you're concerned, the best way to avoid any type of fair housing violation is treat every client as an equal, regardless of their color. There's no black, there's no white, there's only green, and that's the money that they're going to have when they buy or sell. And if you Stay away from race issues, from sexual orientation issues, from gender issues. These are all family status, military veteran status, criminal history, and we'll touch more on that in a second. You stay away from these types of issues and just treat everybody as equal. You will, for the most part, avoid any chance of getting a fair housing violation. One of the reasons this stuff is so important, you can see every single day in your practice. If you sell any minimal number of properties in Sacramento County, part of the transaction is your client, the buyer, is going to get a prelim, and it's going to usually come with the conditions, covenants, and restrictions, which are known as the CC&Rs. On any property that was sold prior to probably 1960, it is very likely that if you actually took a moment to read those CC&Rs, you're going to find that there's probably a paragraph in them that says something to the effect of, you may not transfer this property to any person who is not of the Caucasian persuasion. Some verbiage like that. Now, because of all these laws that have come into place, none of those clauses in those CC&Rs are legal. I mean, there's just no place for them in today's society. The problem is, in order to get those changed, requires you hire an attorney, get so many of the people currently in the subdivision to sign a petition, and then you can redraft the CC&Rs to remove them. The state has pretty much gotten around that by just including an attachment on top of every set of CC&Rs that say, if anything in here violates any federal civil rights laws, they're automatically discarded. So, but anything from gender identity to, immigration status, marital status, any of that stuff you want to stay away from and avoid getting into trouble. Because as it says right here, violation of DRE regulations or real estate laws against housing discrimination by real estate licensee may result in loss or suspension of the licensee's real estate license. Not only that, a fair housing violation on the federal side, I believe it pulls a $25,000 fine. So it's a big deal. Now, there was one thing I wanted to touch on in here. Advertising. I mentioned it here. When you guys are marketing your listings, you want to stay away from phrases like friendly family neighborhood, or walking distance, or family friendly. Any of those types of trigger words, believe it or not, can be a fair housing violation. Why, you might ask? Well, not every quote unquote family is now a traditional husband, wife, child. Some families are, two of either gender, maybe they're mixed genders, and any one of those types of families might object to you calling something a family neighborhood. Or maybe it's a single person that never intends on marrying or partnering with somebody. So you want to stay away from those types of words. Walking distance. I actually heard of a case where a person with a disability responded to a home ad that said walking distance and filed a fair housing violation. And that one was upheld. So you just got to be careful using these trigger words. Stick to talking about the property. You can say close proximity to blah, blah, blah. That's a very vague term. Stick to terms like that. Let's see. I want to talk about this for a second. Channeling, steering, blockbusting, panic selling. These are things that, and you might think of them like this. If you, let's just say you had a client who's a minority and they're looking for a house and they tell you that we want a 3-bedroom, 2-bath home within this price range. They might even tell you we want a home built after 2000, whatever it is. And you do a search, and let's just say the person is an African American, and you limit your search to an area of the city that is predominantly a racial minority, you do that, and that is a violation of fair housing laws. You should do the same, unless somebody tells you they want to live in a particular area, you should do a search just like you would do for any other person, any other neutral person. You want it to cover, wide area, as long as it has their criteria. Do not try to pigeonhole somebody into a particular area because you think they might want to live there, or because you think they should live there. You do anything like that, and you are skirting the law, and it's going to come back at you. There's one comment here about causing panic selling. True story. Probably 15 years ago, there was an agent actually with one of the Keller Williams offices. And I know this circumstance happened because I was competing for a listing agreement or for a listing with this person. And we had appointments with a seller right down the street from here in Thomas Park. And directly in back of this person's home is, to this day, still a huge field, just acres and acres of grass. Well, I had the second appointment. The agent that showed up there ahead of me had his listing appointment. He told the sellers, you better pack this place up and do it soon. Get it sold now. Because I know for a fact a builder is getting ready to break ground on a whole development right over your back fence. That is trying, and this agent was sending out flyers along the street saying the same thing. That is trying to cause panic selling. And that is a violation that can get your license taken away. Well, point of fact, they still wanted to sell their house, but to this very day, that development has never occurred. So I don't know if it was dishonesty or if you really believed it. Regardless, it doesn't matter. Should be telling them stuff like that. You don't want to induce panic selling. Let's see here. The last big important issue here is criminal history. This has become a pretty big deal in the last few years, particularly with rental properties. If you do any property management, you have a lot of homeowners associations, and they are basically running criminal background checks on new tenants that move into their communities. And that's fine for them to do that, but they can't do that until after the tenant has been qualified, that they qualify to rent it, or no, they don't. If they've qualified to rent it and then a criminal history check is done, then there's no violation with doing that. And some HOAs will prohibit people with these criminal histories from moving into their communities. And I think that's probably still in the courts. I haven't heard how that's being resolved yet. But as far as what you do as a property manager, you never want to run a criminal history check before you have run credit, reviewed their job, an earnings qualification, and determined that yes, they are qualified. Service animals, that's another issue that really pertains with property management, stuff like that. That can be a fair housing violation. Let's see. Oh, just touch on this here. We talked about age discrimination and stuff like that. Just realize that there are certain exceptions to those rules. Mainly the ones you're gonna see are senior housing or senior retirement communities. The courts have kind of routinely said that is not a violation as long as they have specific criteria. So you don't have to worry about that. Possible representation of more than one buyer or seller. When you take your listing, this is part of the package that's going to come out. And it, once again, and you're going to see this, it'll also be in your purchase contract. It discusses different types of agency, dual agency, talks about confidentiality of offers, and I'll touch on that again in a second. But a little history, this form was developed probably about 20 years ago. And the reason this form came about is because there was a lawsuit involving Coldwell Banker, and I believe it was in Southern California. And the scenario was something like this. Listing agent goes out to a house, and Coldwell Banker listing agent, and they take a listing on X street. The sign goes up in the yard, and the neighbor sees the sign go up in the yard and calls another agent that happened to be with that same office of Coldwell Banker and says, hey, I want you to come out and list my house. So now Coldwell Banker's got two signs from the same brokerage across the street from one another. One of those agents goes is showing buyers homes, shows the buyer just the first home that went on the market, and the buyer decides to buy that first home. Well, the owner of the second home sues Coldwell Banker and says, you know, you guys, you were representing both of us, and you steered that buyer to the other guy's house. Well, it went all through the courts, and the courts, ruled against the guy. So there was nothing to the suit. But it just so happens that the attorney working for Coldwell Banker that this came to the attention of was also one of the attorneys that prepared these forms for what was then WIN forms. And so she devised this particular form, which although it's gone through a few modifications since then, it is still in use today. And the way I explain this to clients is I do it very simply. I say, this form basically says, look, we represent tons of buyers and sellers all over the place. And we may list the house across the street as well as your house. And if we do that, and some buyer comes along and they decide to buy the other house instead of yours, it's just telling you, look, we're not making the decision for the buyer on which house to buy. That's their decision. So don't sue us. And that's kind of how I have always explained this form. But it does talk about dual agency and things like that again too. As you can see here, offers are not necessarily confidential. Buyer is advised that seller or listing agent may disclose the existence, terms, or conditions of buyer's offer unless all parties and their agents have a signed written confidentiality agreement. Whether any such information is actually disclosed depends on many factors such as current market conditions, prevailing practice in the community, and the listing agent's marketing strategy and instructions of the seller. So that gives you kind of a pretty wide berth to deal with. And what I would tell you is it's exactly as that says. It depends on many factors, and mainly right now it would be such as market conditions. You might be in a market where you're not getting a lot of offers and it's kind of irrelevant. Or you might be in a market where you're getting 20 offers on a property, and maybe disclosing with your client's permission the highest offer you have now. That might be a solution. But whatever solution, whichever way you go with this, it has to be with instructions and communication of your client so they're aware of what you're doing. Let's see here. Wire fraud. Really briefly on this, wire fraud's become a big deal. What's happening is there are people that when real estate transactions go pending, many people have access to that information, for example, through realtor.com or whatever. Well, smart people that can look up owners and tax records and get contact information and address and stuff like that, they come up with these scams where they'll send an email or send a letter to somebody purporting to be a title company or somebody that needs wire, that's trying to get them to wire earnest money deposits or things like that, and or account information or things like that. And so what this is basically telling your client is you want to work directly, make sure you're working directly with the title company or other entity that has authority to be dealing with wire transfer information with you. Don't just give out your information willy-nilly to anyone. Okay, now we finally made it here to the actual listing agreement. So, for those of you who don't realize it, when it's all said and done, a residential listing agreement is exactly what you are talking about when you talk about a contract. In its purest sense, it's a contract. The difference is it's a contract between you and the seller, not between buyer and seller. So, and actually, even to be more specific, it's a contract between your broker and the seller. So, a few quick tidbits just to refresh your memories from real estate practices and real estate procedures that you took as a pre-licensing course. Now, if you ever go to law school, you'll take about a year in general contracts courses, and then you probably have a second, at least a semester in the Uniform Commercial Code, which deals with transactions and the sale of goods, rather good. This is basically a common law contract that's been modified by statute in California. Going back to your pre-licensing classes, contracts require an offer, an acceptance, and consideration. In actuality, it requires a little bit more. So here, the parties to the contract is Keller Williams Realty, in this case, Sac Metro, and John and Jane Smith. The seller party could also be a trust, an entity, and we'll discuss that a little bit further later. But in order to have a valid and binding contract, you have to have in this case, you have to have a seller, you have to have a provider, i.e. the broker, Keller Williams, you have to have a beginning date and an ending date, and you have to have the subject matter, which is the property, and there has to be compensation listed, which is a little bit farther down, and you have to have a sales price that you're going to be offering. If you're missing any one of those, you don't have a valid listing agreement, and you're basically working for free. Now, the reason I say that, because it seems like it would be common sense that you're going to fill in all the boxes. So let's just say you go out to a place and you talk to somebody and he or she says, yeah, I love your marketing plan. Yeah, I want to use you, but I'm not quite sure. I think I want to finish replacing the roof before I put it on the market. I think it'll be done, a week from today, but I'm not sure yet. Well, if that's the case, then what I recommend you do if you want to secure that listing agreement right then and there is you fill in, an estimated start date, and you fill in an estimated end date and all the other stuff. And if it becomes necessary to change that start date, you just send an addendum out, have them sign it and initial it. That way, when you walk out of that place, you've got a valid listing agreement, and there's no question as to whether you're entitled to do the work and what the conditions are going to be. Same goes with the price. If they're not sure what they want to price it at just yet, don't try to get them to sign everything and leave the price blank, because you've got no valid contract. Has to have a price there. Also has to have a commission there. You can see under 3A, seller agrees to pay a broker as compensation for services, irrespective of agency. And you see that little box that says either, and there's an X in that box? You always want to remember to check that box before you put in the percent next to it. If you don't check that box, but you put in a percent, it's an invalid listing agreement, and if the seller wanted to push it, he doesn't owe you a penny. So now let's talk about what number you put in percent. Well, the number you put in percent is going to be the total that you charge for the total commission, and that is the combination of what comes to the office for your listing commission, as well as what is paid out to the buyer's agent. Now, a little bit later in this listing agreement, you're going to fill in what amount of that total percent commission is to be specifically paid to the buyer's agent, and that's the amount that will be referenced in the MLS. quick little tidbit on this. My former business partner, when she first got into the business 20-something years ago, whatever it was, she didn't have anybody training her on this stuff. So she actually entered into the MLS the full amount of her commission. So when this thing closed, on her very first transaction, she got a very important lesson. She made zero money on it, and the buyer's agent made a windfall. So just be careful of that. Office policy, we have a minimum commission that you may take a listing for. I don't talk commission numbers in classes like this because I don't want to take any chance of steering into that legal topic known as antitrust. Commissions in California, for those of you who don't know it, are entirely negotiable. We have a minimum office policy of what we will accept, and I can, if you're not sure what that is, just hit me offline and we can have that discussion. But when you're with other agents, when you're talking about stuff, you never want to have a conversation about, well, I always charge this, and you know, this guy over here is undercutting us by charging that, and you know, I'm just not going to take any of my buyers to show his property. I don't work for that. You get into any kind of public discussions or, you know, discussions with another person like that, and you are endangering your license and you're venturing into antitrust, and you just don't want to do that. Also, if you see right here under 3A, where I put, anytime you see where I put like IE and then I have capital letters next to it, that means that's not something you want to put into the agreement. That's just informational for you. So several years ago, a number of agents and brokers started, in addition to the commissions that they charge, they started adding in regulatory compliance fees and transaction coordination fees, you know, all sorts of, you know, little, you know, add-ons like this in order to pay for their in-house TC or just as a you know, source of income above and beyond their commission. That is actually considered a RESPA violation. So you don't want to do that. I know today there are still agents, brokers that are still doing that, and they're facing a big risk. I actually had a conversation with one of the attorneys at DRE 5-6 years ago when I saw people doing this, and I was asking about it. And that's where I first heard that not only is it a RESPA issue, DRE frowns on it. And if they were to come and audit a file and see that in there at some point in the road, that's going to be a big issue on an investigation. So stay away from that type of stuff. Now, how do you get paid for a listing? Well, there's kind of 3 ways that, you know, if you wanted to enforce them all or any one of them, you can get paid. The first is on an exclusive listing agreement, which is what this is. And I'm going to digress for just 1 second. There are other types of listing agreements. There are open listing agreements. There's net listing agreements. There are single party listing agreements. And, you know, all of those have a place. You know, the more common one that you might see in addition to this would be a single party transaction agreement. And that's, you see that typically where an agent will contact a seller and say, you know, I was just contacted by a client and they're moving here from out of the area. Your house looks like exactly what they want. And they are willing to purchase your house for X amount of dollars if you're willing. And the guy says, well, you know, I don't want to put my house on the market, but if your client really wants to buy my house, I'll do a single party listing agreement for that, just that person. And if they want to do it, then fine, I'll pay you X amount. That's where that would kind of come in handy. But just for general transactions, this will be the common form you're using. And with this, it's an exclusive listing agreement. What that means is, it doesn't matter if the seller finds a buyer, if you find a buyer, or if, you know, Joe Blow at X brokerage finds a buyer. If anybody finds a buyer and they write an offer and that offer is accepted by the seller, then you are due a commission when that deal closes. And so that's like, this is the best type of listing agreement to use because it guarantees you're going to get paid if the guy sells it. The second way you can get paid, and if you notice here, I filled in 90 calendar days. There's a prevailing thought that you should put in a term here that's as long as your listing agreement. There's no right or wrong answer to that. I like 90 days because it's a reasonable period of time. But the reason this was put into the contracts and the way this works is, in the old days, let's just say you list a property and you are halfway through your listing period and the property has not yet sold. And the neighbor walks into his buddy, the owner's house one night. He's looking around and he says, you're selling this house for $500,000. That looks like a real bargain. I'll put an offer in on it. And the seller says to the neighbor, well, wait a second. In another month or another 2 months, my listing is going to expire. So just come back, wait until after the listing expires, and then come back and you can put an offer in it and I can discount it a little bit because I'm not having to pay the commission. There's that situation, there's that scenario. The other scenario is some agent shows a buyer of the property and the seller happens to be home, that's a whole nother discussion. And the seller sees that the buyer is really interested and knows that the listing's going to expire in a week. And he says, come back in a week, come see me, knock on my door. I'll sell it to you and I'll discount it a little bit because I won't have a listing agreement anymore. So this is called, what I call this is called a protection clause. And this is to protect you against something like that happening. Now, I have never actually used this clause. It's just, to me, it's not worth the bad will that it might generate. And especially now with Yelp and everything else that's out there, online reviews, the last thing I want to get is bad publicity. To me, it's live and let live, and there's the other deal that's always going to be out there. However, it's an option that you can use. The key to this, though, is you've got to, prior to the expiration of the listing, go into zip forms and get a form NBP. That's a Notice of Prospective Buyer form. And you have to put any buyer's names that you have introduced to the property. In addition to that, and this isn't commonly known, but if you're familiar, if you're buddies with some of the other agents that have shown the property where the buyers didn't decide to buy, if you're on friendly enough terms with them where you can call them up and ask them the names of their buyers, you're not going to contact those buyers, and you don't want any contact information, only their names. If you put them on the list too, if any of those buyers come back at a later time within 90 days and buy the property, you are owed your commission. So that's way number 2. Way number 3, oftentimes, and I've seen it happen numerous times over the years, you will have this experience too, where, right up until the day before escrow is supposed to close, everything's going great, and the day before, the buyer breaches the contract and says, the heck with you guys, I'm not buying this house. Or buying couple decides they're going to get a divorce right before they're supposed to close escrow. One of them backs out. This is after all contingencies are removed and all that good stuff. So, in that situation, seller is entitled to make a claim of and keep the buyer's earnest money deposit. Now, out here, we don't typically see EMDs of $50,000 or $100,000. When I was selling in the Bay Area, that was very common. Regardless of what the amount is, if that happens and a seller is able to successfully latch their hands onto that buyer's EMD, you are entitled to 1/2 of that EMD up to what your full commission would have been. So again, this is one of those things, it's available to you. I've never done it. The better solution to me is to say, okay, this one fell out, explain to the seller, I'm actually entitled to half of that. I don't believe in that stuff though. You earned it with all the stress they put you under. Tell you what, how about if we just extend the listing agreement by a month? And you start from scratch, you have goodwill with your seller, and everything moves on from there. That's the way I would handle that. So that's the way you can get paid on the sale of the property. I put this in here. Oftentimes you get an out of the area seller, and this is where you would utilize, in addition, seller agrees to pay broker. So let's just say it's an out of area seller and they've got this major yard work that needs to be done every week, and you're fronting the costs for the seller on the promise that he's going to reimburse you. Make sure you put it in here. That way, when everybody's reviewing the final settlement statements, you can add this cost along with your invoices to the commission demand and get reimbursed for that. I wanted to bring to your attention this one here. It's D2. Broker is authorized to cooperate with and compensate brokers operating outside the MLS as per broker's policy. So this situation, MetroList, as you know, is big, and they're getting bigger every day. They are gobbling up MLS services throughout the state. And I mean, the MetroList we have today just dwarfs what it was when I started, when I moved out here to Sacramento. And I anticipate every couple months they're going to be swallowing up a new one. But as it stands, you have out of the area agents that will be representing clients putting offers in on properties. And you as an agent might be representing buyers in non-MetroList areas putting offers in on properties. So as on the buy side, as a buyer's agent, what you should be doing before you send an offer over to the listing side is you get in there and you get a zip form. It's called a CBC, and it's cooperating broker compensation, I think it is. You send that to the listing agent and you get that signed before you send the offer over. If you send that along with the offer and they don't sign it, I mean, it would be kind of a crappy thing for them to do, but legally legally, they don't have to pay you your side of the commission. So just be sure if it's an area outside of MetroList, you send that over. The fact that they're with MetroList, if they are part of MetroList, they guarantee that they're going to pay what they advertise in the MLS. But if this is for use when they are outside of MetroList, or if it's if they're the agent and you are with MetroList, they're going to want to get a CBC signed before they send the contract over to you. Section F1, this is important. Just as when you're working with a buyer or a seller, you always want to ask them, you're not working with another agent right now, are you? That should be one of the first questions that come out of your mouth, because if you start working with them and they have any kind of a written arrangement with another agent, you could be in violation on the code of ethics. But on a listing, it's important because you want to make sure they don't have an active listing agreement with somebody else. And not all listing agreements will end up in the MLS, so you just want to make sure of that. So just ask them, Dave Tanner, who is the CDO at SAR, he is a real estate attorney. He's also a real estate broker. He always recommends you should go back, you should ask them to go back 1 year, any listing agreements they've had within the last year. And if that's the case, you put in that information here. Ideally, you're not going to do anything if that's still an active listing agreement. Number 2, seller warrants that seller has no obligation to pay compensation to any other broker regarding the property unless the property is transferred to any of the following individuals or entities. Okay, so put names here if the seller provides you with, so if they were working with another agent, that agent did the form NBP to notice, to provide notice to the seller of all prospective buyers that looked at the property with his listing or her listing. That's where you're going to put those names in here. You might have to, if it's long enough, you might have to do it with an addendum and attach the addendum with the names. The second way that you're going to use this section of the listing agreement is, and I've had this happen a million times, I've never had it actually work to fruition, is where you're sitting down with the seller and he says, I don't know if anything's gonna happen with it, but my next door neighbor or my brother or my sister have said that they wanna buy the property if I sell it. And so, when you list the agreement, when you list the house, you say, no problem, let's put their names in here. If they buy it, you don't have to pay me a commission. The flip side to that though is, if they are the buyer on this transaction, since I won't be involved in the transaction, I don't work for you any longer on this. Some verbiage like that. What usually happens is 9 times out of 10, they will never come to buy the place. I think it may have occurred once where it actually resulted in a sale, and in that sale, they realized right off the bat that they couldn't do it alone and they needed help, and so there's an opportunity there. Pardon me, I want to get a drink real quick. Okay, moving on. This is an important section because for a couple reasons.
Hey, sorry to stop. I have a quick question
Yeah.
for you.
Yeah.
Hey, so I cut out for like 2 minutes. I had a phone call coming in, and I know you mentioned the part where fronting a client for repairs or fixing their house up before they put it on the market. So I'm curious about that because I actually had this discussion with a different agent in Backville, and a lot of times he will have workers come in and they'll just invoice him and he'll have it come out of escrow, like the remodel. So like, how can we protect? I guess my question is like, how do we do that and keep it all in order and legal and everything?
Okay, so that actually is not an issue. Sometimes, I mean, you'll see it yourself. Sometimes agents will put comments in the marketing and they'll say, sellers in the process of replacing the carpets, things like that. So there's a couple issues that fall into play. One is disclosure. You want to make sure the seller actually discloses the fact that they're in the process of replacing X or putting a new roof on or whatever. Two, if it's a tradesperson, they will generally be paid. They're often. I've done transactions where we just have them paid out of escrow, but you want to make sure that you have something in writing where you're directing them to immediately get their invoices over to the escrow officer. And I would even take the extra step of confirming they got it, because you want to make sure they get paid at the close. And you also want to make sure that you're not going to have a mishap where they didn't get paid at the close, and then you have a tradesperson filing a mechanics lien on the house or a lis pendens threatening to sue for the money after it closes, because that's going to drag you into it. You're going to find 90% of the problems that you would ever have in the real estate business can be avoided just by communicating. And my preferred mode of communication is in writing. There can never be a question of whether you said something or didn't say something if you make it a practice to put everything in writing, or at the very least, after you have a conversation, you do confirming our conversation today, you are going to do this and blah, 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 blah. But doing the work, either leading up to a listing or after you're in escrow, maybe pursuant to a request for repairs or something like that, there's never a problem with that. And I don't think I've ever run into a situation where an escrow officer forgot to pay a bill that was actually submitted to them. Did that answer your question?
Sure, absolutely. So you recommend I have the tradesman submit the invoices to the escrow officer directly, or should I do that?
And just have them copy you so you have a record that it was done. And
Okay.
then, I don't know, I'm assuming you do like I do, but whenever I get up to a closing and it's about to happen, my escrow officers know that I get a copy of the estimated closing statement to review, because I can't tell you the number of mistakes I found on estimated settlement statements, because, let's just say I have an escrow officer that I work with a lot that just assumes that my commission is X. They don't have a copy of the listing agreement, so they don't know for sure. But they'll deduct, a certain percentage of commission. Maybe that's the wrong amount for this deal. Or maybe I agreed to pay for, changing the guy's locks, for the buyer at the close of escrow or prior to the close of escrow, something like that. And it might be missing. And by reviewing that estimated HUD or closing statement prior to the close, you can check all the numbers, make sure it matches to the contract and any subsequent addendums or, additional paperwork. And it's just an added check. It's also an added touch point that you can say to your client, yeah, I just reviewed your estimated closing statement. Everything appears to be in order and matches the contract. So they know that they have that additional affirmation that you're looking out for them.
Awesome. Thank you. Appreciate it.
All right. So 4A, items included and excluded. The typical thing you're gonna put here would be a fountain feature in the backyard that they want to take with them. That's excluded. If they want to exclude it. Not everybody would. If there's a freestanding hot tub that they're saying, oh, no, that's staying with the house. We don't want that damn thing. You're going to put that on here. Additional items included. Well, if you're representing a buyer and there's a freestanding stove, they finally have modified the form so that it definitely shows the spot to mark that as it's staying. Typically, a freestanding stove is legally personal property and the seller could take it with them if it wasn't included in a purchase contract. So, but things like that you put in here. If they also tell you, we're moving to Texas, we don't want to take this damn refrigerator or washer or dryer with us, then you would put those as included here. Obviously, you're going to add those to the MetroList or whichever MLS you're on to show that they are coming with the property. But I want to emphasize to you, just know this. Just because it's in the MLS doesn't mean that it's contractually required to transfer. If you want those items, if you want the refrigerator, washer, and dryer, even though it says it in the MLS, be sure to write it into the contract too. The MLS is not an enforceable contract with the buyer. So you want to have that information in the actual purchase agreement also. Let's see. Oh, this is really important. Typically not a big deal with alarm systems or some purchased solar power system. So oftentimes you'll find leased alarm systems. And it's important for you to know that when you list the property, because if an alarm system or a solar power system is leased, that means that one of two things has to happen. They either need to be removed when escrow closes, or the lease needs to be transferred, I guess, or one of three things, or the leases need to be paid off. In the absence of that happening, a lease does not represent ownership, it represents possession. And that may not necessarily transfer to the buyer. So you could get into problems with the buyer saying, well, it's got an alarm system, there's a panel on the wall here, and it's still working, why can't I keep it? And they don't realize that, well, maybe the alarm system will let them transfer the lease, but they're still going to have to pay for it, for the hardware, not for the monitoring portion of it. So there's all sorts of issues with that. So you want to identify that when you're meeting with the client. Are the systems owned or leased? Or, number two, liened items. Now, this is a big deal, especially now, over the last few years. You may or may not have heard of the term PACE loans. Well, PACE loans are methods of financing purchases for things like solar power, replacement windows, HVAC systems, things like that. The difference between a PACE loan and a normal loan is that PACE loans end up being transferred to the property tax rolls of that home. And they show up on title as a second. So the problem that creates is the Federal Housing Administration, FHA, aka HUD, and VA, they will generally not loan to a buyer buying a house with a PACE loan unless the PACE loan is paid off and removed from title prior to the closing. And the reason is they want to be in first place, not second place. So if you're taking a listing and you learn that there is a PACE loan on title, you need to have that discussion and figure out, is it going to be paid off? Is the amount on that PACE loan going to be paid off as part of the closing? Or are they planning on leaving it there? If they're planning on leaving it there, then you're basically limiting your seller to buyers that have conventional financing or cash. And it's still an issue. You'll have to disclose the existence of this PACE loan. So that's interesting. The lighting just flashed. That's one issue here. The second issue is something to think about when you're getting into the transaction. Just because there's a loan on the property is not a big deal. You'll find, there are companies like Sunrun and whatnot, where some of the financing scenarios they use are leases, and they are more than willing to transfer those leases to the buyer. But you have to be able to provide all those disclosures of the contract, contact people, and everything else right up front the moment you get under contract, so that the buyer can start working with that company's finance people to do what's necessary to get the account signed over at the close. So that's something you want to think about too. Let's see here. I don't need to discuss what an MLS is. Most of you have that knowledge already. One thing I will say is here, our MLS is typically, for most of you that are going to be seeing this, it's going to be Metrolist MLS. This here, I'm glad they added this. This was done several years ago. So the problem is, a lot of agents, and this is still being done today, and I've always had a fundamental problem with this, because it's not in the seller's best interest to use this practice. A lot of agents like to have a pocket listing that guarantees that they can double end the deal. And while that may be okay in a particular circumstance, as a general rule, a pocket listing does not benefit a seller. If you think about it, most people will learn about a property not because you send out a postcard. Postcards are great for generating buyers that you can work with. Open houses are great for generating buyers that you can work with, and there's a valid purpose for that. Same with advertising. Most people find out about homes that are available either from an online source like Realtor.com or Zillow or God knows what, or more commonly the MLS through their agent. So in a market, especially like today, where you have competing buyers, you have numerous offers over asking price, it is self-defeating for the seller to limit exposure to just what their agent has that they can gather from their market, their own individual marketing or sources of clients. The best and highest price is going to be generated by competition. And without putting a property in the MLS, you're slicing competition down to a minimum. So they added this in. It talks about the benefits of using the MLS. It talks about how you reduce exposure, and you might get a lower number of offers and negatively affect the impact of the sales price. All that information that the buyer, or I'm sorry, the seller really needs to be thinking about when they authorize a client not to put it in the MLS. Now, what reasons might there be? I was having this discussion yesterday with a broker, or with another agent, because I couldn't figure out a logical one. And somebody said, well, with COVID the last couple of years, people have been paranoid about having, agents through their house and possibly causing an infection. And, people are just paranoid. I myself am a germaphobe, so I can relate to that. However, if putting up with a few germs is going to generate a substantially larger offer on my property, I'm not going to let that sway me. The other way you can get around that, even if you don't want people traipsing through your house at all hours of the day, you can limit showing times. You can have it in the MLS and make specific showing times where people can come through when you're not going to be around there. There's other ways around it if that's your issue. You can even list the property and not have a sign in front of it so that your neighbors don't know, and still get it in the MLS so it gets exposure. So that's my take on that. That's my feel. Public marketing of property. Now, I told you at the beginning of this that every time I attend a class, I learn something new. This is a prime example. Clear cooperation policy. Whenever you complete a listing agreement, you should be checking this box. MLS rules do not require that residential real property with 1 to 4 units and vacant lot listings be submitted to the MLS within one business day of public marketing. Now, what I'm not telling you is you can't avoid putting it in the MLS when you take a listing without some other things being done. But this, quote, clear cooperation policy is a NAR rule, National Association of Realtors, that has not been adopted by the Sacramento Association nor MetroList. And the reason this was not adopted, and the reason why you have to put a X box here for do not, is because as soon as NAR came out with this policy, and then it started being implemented, several entities started filing lawsuits against those organizations. And they're basically saying that this involves some form of antitrust. Those lawsuits, this has started years ago, they are still in the pipeline being resolved. And the president of the MetroList board at the time that it came about happened to be Dave Tanner. And Dave is the one that decided we are not going to get involved in this litigation at this point. And sure enough, we're one of the few organizations that were not brought into this lawsuit. So I'm going to put an X there. And basically that voids most of this stuff. The stuff that does fall into play is if your client doesn't want to put a property in the MLS, you're going to want to fill out the form SELM, and there's also a separate form, and you can find it under MetroList forms, and that is a form to exclude the property from MetroList for a section between certain dates. And basically it gives all the same admonitions to the seller as to why it's beneficial to have it in the MLS, and if you still want to make this decision, sign here. That form needs to be turned into MetroList when you take the listing, along with a copy of the listing. So that will keep you out of trouble with them. The other box that you want to check here is this one right here. Clear cooperation policy does not apply. And it talks here about submitting the MetroList waiver form to exclude if marketing or coming soon sign will happen more than 3 days. That's the other instance where you have to submit that MetroList form. If you're going to do any kind of marketing of the property, and that marketing is going to occur for more than 3 days before it actually goes live, you need to submit that form showing that you have the seller's permission to do so. I always tell people that as I'm out at their house, that we are going to take professional photographs. Your house is going to be seen all over the internet. So if you have any Picassos on your walls, you might want to take them down. Have anything else you don't want to be seen, take that stuff down also before we do our photos. Your property address is going to be posted, and it allows them to opt out of internet advertising using that form SELI, but you definitely want to explain to them how that is going to hurt their marketability of the home and probably result in them getting a lower price because it will remain unsold. And when people see how long it's been on the market, they're probably going to offer a lower than list price offer because they think they can. People will have ability to write comments and reviews, all this other stuff is pretty much common sense. This one here, it is recommended that you read this paragraph verbatim to the seller when you're doing the listing. And the reason is, it avoids you having to ask them, have you filed for bankruptcy? Are you planning on filing for bankruptcy? Are you insolvent? Are you being sued? Because basically, if you read this word for word, you're just going to say, okay, and this paragraph says that you, the seller, represent that unless otherwise tell me in writing, you're unaware of any notice of default that's been recorded against the property, you're not delinquent on amounts due on your loan, you haven't filed bankruptcy or you're not about to file bankruptcy, et cetera, and you're not being sued. You go through that with them and just, more or less read the thing verbatim. You're not asking them the questions, you're not putting them on the spot, but if there is something in there that's going to affect your ability to transfer title down the road, they're more likely to be honest with you and tell you. Broker and seller's duties. So when we talk about contracts, what we have with a contract, we have an offer, acceptance, and consideration. But when you really dig down into what a contract actually is, in legal parlance, it's a bargain for exchange. It's a detriment for an action or an action for a detriment. One person has to do one thing and another person has to do another thing. And that's the bargain for exchange. So here, with this particular contract that we call a listing agreement, the seller is representing that they're going to do certain stuff. The broker is representing that they're going to do certain stuff. You're going to exercise reasonable effort and due diligence to achieve the purpose of the agreement, which is selling the person's home. The buyer is, the seller agrees to consider offers that you present to them and to act in good faith to accomplish the sale. They have to make it available for showing. If they enter into a listing agreement and all of a sudden decide they don't like you and never make the home available to show and do everything they can to impede you from doing your job, then they've actually breached a contract, and there are ramifications that could be for that. Investigations and reports. There's two schools of thought to this, and I'll give you a little of my own insight on how I feel about it. You guys might feel differently, and it's kind of up to you how you want to handle it. Coming from the Bay Area, when we sold property in the Bay Area at that time, it was very common, and it might still be, I haven't sold anything there in years, but it was very common when we took a listing agreement. One of the things we wanted to do is get preemptive home inspections, preemptive pest inspections, preemptive plumbing inspections. We do all that stuff, disclose everything up front. We didn't have an actual online MLS back then, but we would put in the book, in the MLS book that we got every week, see agent for reports, that type of thing. Today, my belief, and the way I've always conducted my business, but there's other agents that do it this way, is I like to not get reports up front unless there's some extraordinary circumstance where it would be helpful. And the reason I don't like to get them up front is because if you don't have the report in front of you and there's not something obviously wrong, then the seller and you have plausible deniability for having to disclose something that you're not sure about. Once you get the report up front, it has to be disclosed to a potential buyer. And ideally, you're going to want to include those inspections as attachments to MetroList. The reason I don't like to do it that way is because oftentimes A buyer will look at a house before any inspections are done, and they see the house and they love it. And maybe there is some minor issue that comes out in a home inspection where if they had known about that ahead of time, they would have never even looked at the property. But because they've seen the property, they've seen the potential that they have there. They know that, you know, okay, the house is great except for this little thing. I can take care of that, and I can still live in the house while I'm working on that. That issue might not be such a big deal when they find out about it afterwards. And so that's my thought on this. Let's see. That light flicked on. Hold on one moment. I want to turn that light back off. Pardon me, I have old eyes and it's difficult for me to see sometimes. Let's see. That said, in a situation where the seller is going to pay for additional reports or inspections upfront, you want to get that done sooner rather than later. And the reason you want it done sooner rather than later is because once you go into contract, that starts a clock running. And you have X number of days as spelled out by the contract in order to get all of these inspections and reports that you have over to the buyer side. If you fail to do that, sometimes, depending on the report or the inspection, failing to do that within a reasonable period of time can actually extend the buyer's inspection period. For example, if you don't turn over HOA docs by the time period it's required, the buyer will get an additional 5 days to review and approve those. And you cannot write a notice to perform requiring them to remove that inspection contingency until that 5 days has passed. So last thing you want to be in a position where you have to do is contact your seller when he's saying, well, you know, they've already removed this contingency because now is day 17, right? Last thing you want to have to tell your seller is, no, I blew it getting the HOA to issue the documents, so now they have almost another week before they have to remove it. That makes you look bad, also harms the seller. So, you know, little things like that, you just want to stay on top of those. This is your indemnification clause. Seller agrees to indemnify, defend, and hold broker harmless from all claims, disputes, litigation, judgments, attorney's fees, and costs arising from any incorrect or incomplete information supplied by the seller, or anything that the seller that's material knows but fails to disclose to the buyer. Big surprise, this actually happens. Sellers know about something that's wrong with the property and they don't tell you. But trust me, buyers find out a way to learn about that stuff. It happens all the time. And we'll cover a lot of this stuff a little bit in more detail when we go through disclosures on a different class. But you know, just beware, sellers always don't tell the truth. You'd hope they would, but they don't always do it. Again, we come back to the agency disclosure. This box is checked automatically in zip forms whenever you generate this form. Just another added reinforcement that they've been given the agency disclosure. Again, it talks about possible dual agency here. And I think it automatically checks the box for possible representation of more than one buyer or seller, disclosure and consent. That's an automatic included form with this. This is security insurance showing audio and video. My standard spiel when I'm meeting with a seller is I talk to them about, because especially now it's really big, people have surveillance systems set up in their homes and so on and so forth. You just want to give them a quick warning. Look, people have a right to privacy, and because you're inviting them into your home to see it, they even have a right to privacy here while they're in the home exercising that right. So if you do have surveillance cameras floating around the house or audio listening devices, just put a sign up somewhere conspicuous where they can see it as they're walking in the door so that they know. So that's one issue. The second part to this, and this is really big, everybody I know, everybody I know has had an experience with a friend or family member or somebody they know where somebody has stolen their identity. It's just, it happens all the time. And there are people, we've heard about situations where you hold an open house, people will come in and they will steal things from the open house. I think there was just something a couple weeks ago out in Roseville where they actually were posting somebody's picture on the news, a couple that were taking things from a home. But the bigger issue is somebody comes into a home and they steal financial data, copy of a checkbook or a checkbook, bank statements, tax forms, especially this time of year, things like that. So one of my standard admonitions that I give to a seller client is before we actually go live and people are going through your house, I want you to take any financial records, any bank records, tax records, credit cards, jewelry, and I want you to put it all in someplace safe. Don't leave any of that stuff leaving out. And I say, I have never had a client that has come to me and said, Bruce, one of the people in the house stole something, stole X, stole Y. Never had that happen. By the same token, I don't want you to be the first. So just put it all away. Don't even take a chance. Again, we go into photographs and internet advertising. People will be able to see a lot of stuff. They'll be able to tell a lot of what's in the house by the online presence. You want to just warn them again, that goes back to putting stuff away when people are going to be there. Key safe lockbox, you want them to authorize you to put a lockbox on the house. That is the best way to give access. Sometimes you can't avoid having a seller that says, nope, it's going to be appointment only. I have a dog and I got to make sure the dog is rounded up, or I want to make sure the cats don't get out, whatever it is. You're not going to be able to actually use a super lockbox. It'll have to be by appointment only, but try to get a lockbox. If there's going to be a lockbox, or if there is a tenant-occupied property, you have to involve that Form KLA. And the Form KLA both gives them permission to put a super on the house. It also gives a spot where the tenants can agree to allow the property to be shown and to allow agents and you as an agent to go onto the property. And I typed in a little note there to remember that a tenant who is renting a property doesn't just rent the house or the driveway. They rent the entire property from lot line to lot line. And if you do not have that tenant's permission to step onto the grounds, to plant a sign in the ground, or to have a sign company plant a sign in the ground, or to put a Supra on a gas pipe on the side, or whatever it is, you are trespassing. And you don't want to get into that situation. Now, side note, I'm just throwing my opinion in here. I have been on the horrible receiving end of having to try and market a tenant-occupied property before, where the tenants, and this has been the overwhelming majority of them where I've run into this, where the tenants don't want to have to move and they do everything they can to make that house as messy and as unmarketable and put up as much resistance as they can to getting it sold. So my personal bias is I like to have a property that is not tenant occupied, and I would rather wait until it is not tenant occupied before I take that listing. Now that's me. I'm not telling you that that has to be your policy. You might be willing to deal with that, until you have are coming from a period of abundance where you have enough listings where you don't need to take that one. But that's how I feel about trying to market tenant properties. I think with maybe one exception, I've had most of my experiences trying to do that have been pretty poor. So that's that. If you're dealing with a trust, then you're going to want to, if your seller is a trust, and that is becoming more and more common. And as a side note, when you're dealing with buyers, as you close escrow, especially when there's, family involved, where there might be children and things like that, I highly recommend you talk to them about visiting with an attorney and getting a living trust set up. Number one, there's an advantage if a party passes at some point down the road. It basically avoids the need to have probate, which saves money and time. Number two, within that, if they have a family with children, you can make they can make specific decisions as to who is going to take care of those children, who's going to manage the money for those children, et cetera, et cetera. So it can be very helpful. And again, it's one more touch point where you can show that client that you're working for them and build up that faith in your ability, so that a couple years down the road, when they want to sell that house, your name is going to be top of mind with them. And I can tell you from my own personal experience, my parents were killed when I was 5 years old in a plane crash. They did not have a trust, and their estate was an absolute mess. And so I am very sensitive personally to the issue of having a living trust set up. Let's see here. This sentence here, number 20, remember I told you at the beginning of this class that there's one party to the contract, which is the seller, and the other party is the broker. Now, you are an agent of the broker, and so you're doing this paperwork. But by having this little clause here that says management approval, that, assuming you turn your paperwork in on time, if there were a mistake made in here, this is our ability, this is the safeguard for our ability to be able to say, whoa, pump the brakes, we need to redo this and change this. So this is just our safety, because if I have some issue with something that was written here, or if at another brokerage, if the broker of record has some issue with it, there's a major mistake or something, this enables us to cancel this and start from scratch with a corrected one. Point of fact, a listing agreement, again, is a contract. It's what we call a bilateral contract. And what that means is, you can't just say, I quit or I cancel. You can't say it, and the seller can't say it. Now, what happens oftentimes is, seller decides they don't want to work with you anymore, and they say, I want to cancel the listing. And you, as an agent, you don't want them bad-mouthing you all over Yelp and, to all of their neighbors, and you say, okay, fine, we'll cancel it, no harm, no foul. At least that's typically been what I've seen. But when both of you are agreeing to cancel it, that's perfectly fine. But when the seller is a problem seller, and you've just had enough, you've had it up to here, you're done. You don't want to see this guy again. You don't want to talk to him again. He is so much of a problem, he gives you nightmares, and your stomach is lurching at the thought of working with him. Ironically, you can't just go and send him an email or knock on his door one last time and say, I quit, find another agent. You cannot, one side to this contract can't cancel. It has to be through mutual agreement. So it's something to think about. Dispute resolution. Well, what you're agreeing to is seller and broker agree to mediate any dispute arising between them regarding the obligation to pay compensation under this agreement before resorting to arbitration or court order. So mediation is applicable to compensation issues, not anything else. And mediation is not binding. So mediation is you sit down with a third party, you, the seller, third party, and the third party says, okay, well, I know you feel this way, you feel this way. What about if this guy does this, and would you be willing to do that? And they try to basically buffer the two of you, into coming up with an agreeable solution. If mediation fails, then they can go to either arbitration or go to court. But they can only go to court under certain items. So let's just say The dispute you have is you sold their house for them, you closed escrow, but at the close, they refuse to release your commission. You're not getting paid because they don't like the haircut that you have. They don't like the fact that you didn't wear the right clothes, whatever, doesn't matter. They refuse to pay you. Well, although commissions are starting to inch up a little bit, typically, at least over the last several years, you might find a commission for $10,000 or less. Well, in this particular case, any action that could be covered by small claims, you can go directly to small claims court. That is excluded from this. So even if, let's just say the commission was $15,000, well, the maximum in small claims is $10,000 in this county. You could still sue for $10,000 in small claims court, get a judgment. Well, then the whole issue becomes, can you collect? And that's a whole nother story. But at least that way you could get a judgment for your amount of money. There are certain other issues that can't be dealt with in court, and those are issues concerning judicial or non-judicial foreclosures, some action to enforce a deed of trust and mortgage, installment land contract. I don't think any of you will ever be dealing with those unless you get a client that goes into foreclosure. And then, of course, there's arbitration. Arbitration is very much like mediation, except in the end, the arbitrator will make a decision and rule in favor of one side or the other. Typically in an arbitration, they're not going to give a little bit here and a little bit there. It's all or nothing to one side or the other is what you're typically going to see. I've highlighted this area here under entire agreement. This is what you call in a contract, this is what you call a merger clause. And what a merger clause does, if it's in a contract, is it prevents any outside communications, oral or other written communications that were not made a part of the contract, listing contract, that should have been included in the listing contract if they were really truly meant to be a part of that contract, from being admitted into it. So it basically says you can't add in anything that you discussed or talked about or made a note about prior to signing this agreement. You can't add that in and expect it to be legally binding. So anytime you're in a contract, whether it's in a purchase agreement or purchasing a car at a car lot or wherever, if it has a clause that says this is the entire agreement, and you are expecting other things to be included, even though they are not physically referenced in this document, you want to deal with that at that moment and make sure it gets put in. Representative capacity. Again, RCSD-S is the representative capacity signature disclosure. That's going to apply when the property is held by a trust or another entity. Anytime it's not going to be John and Jane Smith that are the actual sellers, you're going to want to use that representative capacity disclosure. Now I've included, or I have one in the documents that I'm using for this, and I'll show you. The issue is that form, I'll pull it, actually it's in the other batch, I'll pull it up now. Here, maybe it's in here. There we go. This is the trust advisory for a seller that you would fill out if it's a trust that's selling it. And then this is the representative capacity form. And you see a note that I put here can be signed at any time from start to close. So let's just say you visit a seller and you find out, you think that it's in the name of John Smith and Jane Smith. And then you find out from title that, oh, wait a second, no, this is being held in the Smith Family Trust of 2002. At that point, you can pull out the representative capacity signature disclosure, fill it out for your client, have them sign it, and what this allows you to do is all of those signatures that you had signed as John and Jane Smith are still appropriate. You don't have to worry about redoing all the documents and adding in the name of the trust. This kind of fixes everything retroactively. then, oh, if you have more than 2 sellers, and I hope for your sake that it's limited to 2. Sometimes you get a whole family of people that own a property and they all have to sell. You can do that a couple of ways. One, you can still do one name on each line as we did here, or you can probably modify it within zip forms where you put under first name, you just spell out John Smith on the second line. For the last name, you spell out Jane Smith, and then you can put 2 other family members in the same way. Or it's just as easy, you attach an additional signature addendum and put them all in there, and that should work too. Seller's advisory, really quickly. Basically, this is telling the seller all the things that they need to disclose and how you're going to disclose them. They're going to do a TDS. You're going to do all of that stuff that's going to be provided over to the buyer. The biggest thing that I wanted to point out here, there are 2 types, and I explain this to the sellers kind of like this. I say, look, there's 2 types of disclosures you're going to need to make, and there's a number of ways you're going to make them. You have general disclosure duties, and you have statutory disclosure duties. The general disclosure duties are things like, gee, there's a big bull mastiff that lives next door, and at 2 a.m. every morning, he is barking like clockwork. That's a general disclosure. Or I had a mold problem in this bathroom, the number 2 bathroom, and in 2015, I had all the walls pulled out by a mold remediation company, and they, made sure it was taken care of. That's a general disclosure duty. Statutory duties are ones that are covered by what we call a natural hazard disclosure statement. And typically we use third-party companies to provide all of those statutory disclosure duties, such as you're in an earthquake zone, you're in a flood zone, you're in a high fire area, so on and so forth. Those are all specific disclosures that you are required to make in California. And I explained that to them, and that kind of covers this area here. The next thing I talk to them about is when we do these disclosures, you as a seller, have to be absolutely honest. If you try to be deceptive, it'll come back and bite you in the butt later and you'll be in court. If you know of something and you don't disclose it, I guarantee you the buyer's going to find out about it. And they will. I mean, the classic was there was a front like garden window on a home in South Natomas, and every winter, because of the grading on this house, the water would rush under the siding on the front, and it would actually come into the living room and soak the carpet. And this was going on for years. And finally, the summer before they sold the house, the homeowner fixed it all on the inside. He painted the outside and made it look all nice and pretty. And then the buyer bought the home. Well, that following winter, the next door neighbor happens to see the home buyer trying to get rid of the water in front of the house, and they start talking, and he complains about the leak that happened. And the neighbor says, oh, that's been going on for years. Bob's just not bothered to have it fixed. And right then, there's a lawsuit. And it's a failure to disclose, which is fraud. And fraud actually extends the statute of limitation, which a buyer can sue. So, there's all these things that can happen all because a seller lied or failed to disclose something. And that's why it's so important.
I want to ask,
yes?
if the seller doesn't tell the agent anything, would everything fall onto the agent or just the seller?
Okay. So the question is, if the seller doesn't tell the agent anything, would the liability still fall upon the agent? And it's kind of a yes and no answer. So the way that it would fall on the agent is when you do your agent visual inspection disclosure. There's a case that I referenced a little bit up. It's called Easton v. Strasburg. And that was the case in California that required all agents to do a visible inspection of the property. And that doesn't matter if it's the listing agent or the buyer's agent. Both agents have to do a visual inspection of the entire property. They don't have to do things like climbing up on roofs. They don't have to crawl under houses. But anything they can see walking around the house, if it's something that is out of the ordinary, they should report it. So what I do is I take that form and I walk around the house, and I mean, I'm very detailed. If I see nail holes in a wall, I'll make note of it. If I see peeling paint, I make note of it. And I try to note the area that I'm seeing it in. If the house is riddled with dry rot all around the circumference of the house, I'm not going to list every area that I'm seeing it. I'm just going to make a comment. The entire exterior of the house I observed peeling paint and what appeared to be rotted wood around the entire home. You know, something like that. If there's a stain on a ceiling, you wouldn't say it's a stain, or you wouldn't say there's a leak. You're saying, I see what appears to be some kind of a moisture mark on the ceiling. You're going to do all that stuff. So going back to your question, if it is something that would have shown up in your agent visual inspection and you didn't make note of it, you could be liable for the damages. If it is not something that would have shown with your diligent inspection, you can still be named in a legal action, but it's unlikely that they would be successful against you. Okay? So, and I'll tell you all, if there is ever litigation, the attorney on the plaintiff side will always name both real estate agents, their brokerages, as well as the defendant. That is standard practice. It doesn't mean you did anything wrong. It just means they have to name everybody up front. Otherwise, they can no longer go back to that person later if they learn other information that would have shown a solid case against that person. So I have been very fortunate in my 30 plus years. I have been sued once in small claims court, and that's it. And in that particular case, I didn't do anything wrong. I went into small claims representing myself as well as Fannie Mae, Federal National Mortgage Association. It concerned an REO sale that I did. And it was judgment for me and for Fannie Mae. So knock on state court, I've been very lucky. But it doesn't mean you should let your guard down. You should think about these things and just know all you can do is bulletproof yourself, and you make an effort to be fair, equitable, do the right thing, represent your client the way you're supposed to represent him or her, and that reputation and that work process will go a long way to keeping you out of problems like that. Death and other disclosures. Again, if the way the law is written, if somebody died in the property that you're selling within the past 3 years, unless they died from human T-lymphotropic virus type 3/ whatever, you do not have to disclose. If it is less than 3 years and it did not concern that particular ailment, the seller must disclose and you must disclose. So it's kind of important that the seller let you know. Why is that so important? Because there are certain groups of people that a death in a home is a very big deal. One that comes to mind, I dealt with a lot of Asian buyers, and they look at, I think it's feng shui or something, but it's like very bad omen for them to buy a home that somebody has died in. Me, doesn't bother. I bought a house where the guy died in the master bedroom. Never bothered me a bit. Never gave it a second thought. But some people, it's a big deal for. So if they died within the last 3 years, and unless that particular disease is involved, you have to disclose it. If it is more than 3 years, do you have to disclose it? You only have to disclose it if you are asked the direct question about it. and you know about it. So if the buyer says, okay, fine, nobody's died here in the last 3 years, did anybody ever die in the house? And you happen to know that the seller's mother died there 10 years ago, you have to disclose it to the buyer because you have personal knowledge. Let's see. Withholding taxes. This is a real big deal for some sellers. Federal and state law both have issues concerning withholding. With the federal law, there's issues if it's a foreign national that it puts certain withholding requirements on the seller's proceeds. Actually, on the seller's proceeds. The federal government wants to make sure, A, there's no money laundering going on, so they're looking at that stuff. Also, if there's tax issues, they want to put a hold on that. The bigger issue you're going to see here in California is from the Franchise Tax Board, and they have a rule in place that if you're an investor and non-resident, that the title companies will actually, it's done at the behest of the buyer, but they have to withhold 3 1/3% of the seller's proceeds as a deposit on what that seller is going to owe to the Franchise Tax Board. So that's just something you want to just tell your seller to consult with their CPA about, so they understand what, if any, tax ramifications are going to affect them. Again, tell them about prohibition against discrimination, and this is for the seller's benefit. We're going to tell them, we don't discriminate against any potential buyers. I don't care who you don't like or who you do like. If that person's money is green, and if they're ready, willing, and able to buy a property, if we are allowing home showings to anybody, then they are allowed to come in with an agent and look at your house. And if you don't like that, then I need to refer you to a different agent. Government required repairs. I just let them know that, as part of closing, you're going to have to make sure your water, for California, you have to make sure your water heater is properly strapped. You're going to have to make sure your house has working smoke detectors and a CO detector. And if the house was built prior to 1978, then we have to do a lead paint warning to the buyer. And let's see. Post-sale protections. This is one of the biggest things that will help keep you out of court in the future. And many of you are probably doing it already. When you represent a buyer or when you represent a seller, if the buyer is not willing to pay for a home warranty, sometimes the best investment you can make, especially on a house where you may have some doubts about how much longer the stuff is going to last, invest in either trying to talk to the buyer's agent to paying for a home warranty, or you pay for a home warranty for the buyer. Home warranties will keep people out of court because if an appliance breaks down, as long as it wasn't a pre-existing defective appliance, if it's still working on the date the property closes escrow and it hasn't failed at that point, it's fair game for a home warranty. If you know the dishwasher is not working at the close, hopefully if you're transferring the dishwasher with the property, which you should be because it's installed, you're going to make that disclosure if you know that it doesn't work. You're going to make that disclosure the other side. But at any rate, it would not be insurable under a home warranty because it was already defective. And it's actually insurance fraud if the person had a home warranty and then applied to have the dishwasher fixed or replaced. Again, it covers safety precautions. Put your stuff away. Don't let anything be in the marketing photos that you don't want people to know you have. Last thing I always tell them here is under expenses, just know you, not me, are responsible or any cost of repairs or anything that has to apply with your duty to get the property ready to sell on the open market. I pay for all costs of marketing. That's not on you. But if you agree to do repairs, that's coming out of your pocket, so on and so forth. Privacy, I'm not going to say much about that. Just know, for those of you who still carry paper files around with you, and those of you who keep electronic data files, make sure you keep them secure. Don't drive around in the streets and park at the Walmart parking lot with a stack of client transaction folders sitting on your front seat. It contains personal information of many people, and if it gets stolen and people use that information corruptly, you can be liable under California Consumer Privacy Act. Keep your data secure. Any questions? Yes? No? Can you all hear me?
Yes.
Yes.
A lot of information.
Okay. Any questions? All right then.
Nope.
Sorry. Did you have something, Joshua?
No questions.
All right. Thank you for attending. I hope.
I actually had a question.
Yes.
Is this recording going to be available for us to go back and look at it?
Well, I hope so. I hope so. That's my goal. And I will verify that. My goal is to record all of these and have them set up on the website so that you can listen to them while you're sitting at home in your PJs on a Friday night and refresh it, whatever you need to do.
Okay.
I think that would be helpful for everyone.
Okay. Yeah, sure would. I had one more question. When it comes to like explaining the contracts, like if we're doing a listing agreement with the seller, is it okay to kind of like outline the most important things that we know we want to make sure that the seller understands? Or would that not be professional to do that? Like underline with like a yellow marker?
No,
Okay.
do not do that. The only places I would ever use a yellow marker on a listing contract, and it's more to help you avoid a mistake, is all the spots where they need to sign and date and initial. I've done that forever, and it's never been a problem. But you don't want to. The reason I would not suggest doing things like I did here with the red underlining and all that is the second you start doing that, an argument could be made, if there was ever a disagreement, an argument could be made that, well, gee, me, Mr. Seller, I thought only the important things were underlined. I didn't pay attention to this. And you don't want that. So just the signatures and the initials and dates, the important
Okay.
stuff that you need to make it a valid contract. And always, no matter how you do it, if you're the high-tech person that does this meeting with the client on a tablet or some sort of a writing instrument electronically, or whether you're the kind like me, the old school that likes paper and leaves an extra copy there so that they can have a copy when you leave, make sure you leave them a copy at that moment. And just kind of a side note, I like to try to do all of this at one instance. And it might take a few hours if you're doing it right, but you go through the initial listing paperwork, and then from that point on, they're working on their disclosures that you also brought with you. And while they're doing their disclosures, you're walking around the house with your ABID and you're filling that out. And that way, say in a hot market like this, you're going to put the property in the MLS on Monday, and on Tuesday you expect to have 5 offers, or 3 offers, or 2, or whatever it is. And if you expect that you're going to be accepting something that fast, you have everything you need, all of the disclosures, to hand over to the buyer on day one, once escrow's open. And that is one of the biggest ways you can get into trouble, is not having that stuff to turn over. The other thing too, and I'll cover this later on a disclosure class, but when you get that TDS and all these other required forms back from that seller, make sure you look through them. Don't just take them, scan them, and put them into electronic format. Look at them. Make sure every single question is answered. And the reason that is important is because if you turn over a TDS or a supplemental disclosure, whatever it is, to the buyer side, and they missed a question or they did not answer a question completely, that is the same as not having been provided with that form. And that gives them additional time to drag the thing out before they remove their contingencies. So don't just do a paper shuffler. Look at the form. You're not allowed to tell them what to say, but you can look at them and tell them if something is missing or they did something incorrectly. Okay? Anything else? All right then. I thank you all very much for attending, and I look forward to stepping in and doing some contracts classes and some disclosure classes and some other things. So I look forward to working with you guys again. And on a side note, if you have any feedback that would make this thing better, please email me, bruce.hammer@kw.com. I won't take offense. I will take all constructive criticism. You guys are the ones that are supposed to benefit from this stuff. So listen to any feedback. All right?